Property disclosures, the real estate professional's guide to reducing risk. Page 20, Chapter 2, Punishment for offenders who have already served their sentences. The nation's highest court affirmed the right of states to post sex offenders' names, addresses, and photos on the internet. Hawaii's Megan's Law declared unconstitutional. State versus Bani, 97, Hawaii 28536 P.3D1255, Hawaii 2001. Eto Bani pled no contest to a fourth-degree sexual assault charge based on his grabbing of a minor's buttocks while he was allegedly intoxicated. As mandated by federal legislation, the state has adopted a Megan's Law requiring the trial judge, as part of Bani's sentence, to order him to register as a sex offender because the victim was a minor. Bani appealed the registration part of his sentence, claiming that the law was unconstitutional. Because the registration requirement is for life and is made available over the internet, the Supreme Court of Hawaii ruled the law unconstitutional. The court found that the law's failure to provide individuals subject to its requirements any method of appealing the requirements before this information was made available to the public constituted a violation of due process. Connecticut's Megan's Law declared unconstitutional. Doe versus Lee, 132 F SUPP 2D57D, Connecticut, AF affirmed or whatever, 271 F3D382D, Circuit 2001. The Megan's Law statute in Connecticut imposed certain registration requirements upon anyone convicted of certain offenses. The challenger, who claimed to be a non-dangerous sex offender, filed a lawsuit challenging the constitutionality of the law on due process grounds and also as an impermissible ex post facto punishment. Both the challenger and the state filed motions for judgment in their favor. The challenger argued that the classification stigmatized him and that the law did not give him any means to challenge this classification. The court ruled that the challenger had demonstrated that the law did indeed stigmatize him because the law classified a wide variety of offenders in the same manner. The court also ruled that the law's extensive registration requirements constituted an alteration of a legal right. The trial court ruled the law an unconstitutional violation of the Due Process Clause. In March of 2003, the U.S. Supreme Court upheld the constitutionality of Megan's Law in Connecticut. The Supreme Court unanimously ruled that the procedural due process clause did not entitle the challenger to a hearing on whether he represented a continuing danger to society. The court further ruled that the constitutional requirement of procedural due process had been satisfied previously, as the challenger had already had an opportunity to challenge his convictions through the judicial system. Therefore, the Connecticut Appellate appellate court decision was reversed. Page 21. Neighborhood safety. Real estate professionals are often asked questions regarding the safety of neighborhoods by buyers and renters. The best way to answer such questions is by informing purchasers and lessees where they can go to get statistics on neighborhood safety, such as the local police department. There is less liability for brokers and sales associates in being the source of the information and not the source itself. It says, here's a little picture right here. I'll stay here while you look at the house. I don't like to leave the car in this neighborhood. And it shows the real estate agent. That's pretty funny. Property management, crimes and dangerous conditions. Large settlements are being awarded against landlords for crimes that occur on the property. Cases typically depend on whether the property managers say the neighborhood is safe, whether they knew or should have known that conditions on the property made it susceptible to criminal activity, or whether they provided inadequate security. Plaintiff's theory that it was a matter of time before repeated burglaries involved violent acts prevails in large settlement against property manager. Elizondo versus Brightwood Townhomes, number VC 08497, 2000 WL 1358018, Cal Sup, LA County, July 26, 2000. The 36-year-old plaintiff was walking into the garage at his condominium when he surprised a burglar who shot him in the spine, leaving him a quadriplegic. His son, also a plaintiff, was shot in the arm and chest. The plaintiffs alleged that the defendants did not take appropriate precautions in light of increasing criminal activity at the condominium complex, including burglaries, car theft, vandalism, and trespassing by gangbangers. The 4 crimes immediately preceding the shooting were burglaries of condominium units close to the perimeter fence, where it was suspected that the perpetrators gained access by climbing over the fence. The plaintiff's theory was that it was just a matter of time before a resident was seriously hurt. The complex and its property managers were aware of the criminal activities and had discussed using guard patrols. Notices warning of the criminal activity had also been sent to residents. The defendants agreed to settle the case for $2,300,000.